Doogue. Bill is an accredited criminal law specialist who's been practicing for over 20 years. His firm, Doogue, O'Brien & George, has 7 criminal law specialists in it, and all 13 solicitors practice exclusively criminal law. They represent Nasir Ben Baruka, an Islamic cleric in the terrorism trials. They successfully defended each of the truck drops in both the Kirang and Chihuahua train and truck crashes. They acted for Peter Dupas in his recent court of appeal case. They are currently acting for one of the accused in the Reserve Bank robbery committal. They tweet, they blog, and are very active in social media. Before I talk about what Bill will be sharing with us today, there was a great article published in the LIJ in 2012 by Caroline Ford titled "Working the Net, Crime and Social Media," just to demonstrate the broad effect social media is having, specifically in a criminal jurisdiction. I'll just read a few lines at the beginning of the article, which says, "Social media is reshaping law and order. It's changing how criminals commit crime, how police fight crime, how lawyers prosecute and defend people accused of crime, and how courts administer justice. All quarters are finding their way with new technology, which might be considered equal parts friend or foe. Crime is committed via social media. It is also resolved the same way." Bill, on a personal level and as a practice manager, engages in social media through various platforms. What I just read demonstrates the many elements that social media affects in a criminal jurisdiction. Therefore, Bill will broadly discuss some of the recent developments, trends, and issues, and following Bill's comments, we will eagerly take, the panel will eagerly take your questions that you've been writing with those great pens and pads provided by this great place. Bill?
I'd have to say that's a CV that is likely to make people hate you from the start. But because I'm a criminal lawyer, I might just ramble a bit, and I'm not going to be quite as deep as the other gentleman. The disasters of social media for us are heavily outweighed by the benefits. And the starting benefit is information. And if you're not on Twitter, get on Twitter, because it's not about writing whether you've had a coffee or photographing your meal and putting it up there. It's about finding people who do a similar job to you and then linking to them. And you send each other posts, so you send each other links to interesting information. And I would learn 1 or 2 things a week on Twitter that I don't know that I think might help my practice, or that I store away so that I can use them against the prosecution at some future time. One example being that I've been corresponding with a lawyer in Texas, and in Texas they have a really interesting way of presenting to juries what beyond reasonable doubt means. But for Twitter, I wouldn't have made that connection, and I wouldn't have got that information. And the tweeters, much as we hate it, the tweeters in America are very interesting ones. They have, so you have, say, the jury experts, or the people who do studies of juries after they've seen the trial, which is prohibited here by the Juries Act, I think it is. And so they tweet little articles that give you really interesting ideas about how you should present a case to the court. So it might be they do a study on, should your client wear glasses? And the answer would be, hands up those who say yes, and those who say no. Yes? Well, you're right, and the ones who didn't might want to put their hands up. Another example being, if you've got a white-collar criminal, accused, sorry, if you've got an accused who's committed some major financial crime, should they wear a tie in court? And all those who say yes put their hand up, and all the no's, and the no's have it on that one. And these studies are quite fascinating because, as glib as they sound, they're actually in great depth. They study large samples of juries. I never would have known some of that stuff if I hadn't been on Twitter. And so, as you'd guess, now my clients go to court without ties on and wearing glasses, and of course get better results for it. Or the classic one that we all know to some extent, which is what sort of jury do you want on a sex trial? And it's counterintuitive in a sense, but it's middle-aged women are more likely to acquit than any other group of jury members. And you see that daily in the county court, that you're selecting and trying to get middle-aged women onto the juries and teachers off. But that's, sorry, I rambled away a bit from social media. The changes to legal aid, which are pretty profound in the state at present, and very disturbing if you consider the rights of an accused to matter. They are all over the Twitterverse. The English examples of how their legal aid is changing and what that means is all over the Twitterverse. And again, there are common themes in these things that you can draw across in your arguments against other people. Avoiding disaster while tweeting, well, as a lawyer, and generally I don't avoid disaster, so but my opinion would be that you tweet what you want, and it's the same as posting. You post what you want. Either you have a well thought out position or you don't, and either you're willing to stand by what you say or you don't. And the only caveat on it is that if you wouldn't put it in a letter, don't put it on social media. I essentially don't see there's that great a difference. You don't tweet late at night, probably don't write letters late at night. You don't tweet a drink, which unfortunately you see people do occasionally. But to go to the greater impact of social media is in the court system themselves, and as Wilson was saying, the impact's immense, and it's hard to, when you're immersed in it, it's hard to think of when did it actually change the way it has. But in my opinion, that if you're a criminal lawyer who doesn't get social media, and I'll just restrict it to criminal lawyers because I don't know commercial law, I think you're negligent, and I think it's as simple as that. If you don't understand Twitter, if you don't understand Facebook, if you haven't heard of Instagram, if you don't know about Foursquare or location-based services on the net, you're doing your client a disservice. They're all incredibly powerful things that come up all the time in court cases. And that, in some ways, social media can't be divorced from technology, and you have, as a corollary to that, you have screen dumps, you have dumps from towers to get SMSs or phone call locations, and you have subpoenas to the telcos. All those things, or subpoenas to Facebook, subpoenas to Twitter, all those things interact, and you have to have a grasp of them. If you don't know that you've got a shelf life when you're going to subpoena someone's SMSs, and you wait, then you wait till the trial proceeds, or you wait for this, or you wait for that, you're going to get slammed by the telco, and you're not going to get a bit of evidence that might be crucial for your client. It might stop them going to jail for 5 years, 10 years. But to illustrate that ambit inside the court system, the starting point is pre-trial social media disaster. And I'm just using examples from our cases here. I think all criminal lawyers would have similar ones, that you get the client who vents on Facebook and they say, I'm going to kill him. And unfortunately that gets forwarded to the person who was said about, goes to the police, and then they're facing charges of threat to kill, which is obviously the social media disaster for the accused. Or we had another client recently who posted that they were going to take a hit out on somebody, and again, that person is aggrieved and stupid enough to take it to the police, or aggrieved and stupid enough to charge our client. So he ends up with a social media disaster. The second thing is pre-trial preparation and social media disasters. And that is almost invariably where the prosecution come unstuck, which is, for us, is a great thing. The example being underage sex where the issue is belief in age. So you have a situation where a complainant, what the complainant is saying on social media is important in the assessment of the truth of their version. And so if when a person comes in, you don't find out if they're on Facebook or Instagram or Twitter and try and get it, then you're, as I was saying, you're being a bit derelict in it all. We've won a number of those sort of cases because we've found material where the person is making statements about their age which are inconsistent with what they're saying in their statement to the police. We had, I had a matter recently where Instagram, which is a photo sharing and writing, people post up pictures and photos and they write comments and reflect on their life and things like that. I had a person recently who was interviewed for a rape charge, and normally, given the climate we're in, a rape charge after interview just goes straight to trial regardless of whether the person is a fantasist or not. But in that case, Instagram was the basis for those charges not going ahead because we were able to present the coppers with the Instagram post and say, you can't be serious, you cannot run this trial, and credit to them because it's rare, they didn't proceed against the eye. The next stage in the court process is the sentencing process. One of the social media disasters we had there was we had some clients, a group of guys, we were acting for one of them, they'd gone out and robbed some people and beaten them up, and we were going to court for sentencing. So we were there ready to say how remorseful they were and how that changed, and we had all our little reports there, and the prosecutor slid across the table their post on Facebook from a couple of days previously where they'd been saying, we did them Broady style and things like that, and so we had to just not make any assertion about remorse, and their plea became quite a train wreck. So that's, and in some ways that's a fitting social media disaster. They deserved that disaster. And then the final process in the court is the appellate process or the appeal process. And we had one client in a trial where the allegation was belief in age. So the complainant was 15. The boys said that she had always maintained to them that she was 16. She denied it. She said in cross-examination, never would have done that, never would have told anybody that. The jury's accepted her version of events, and so the boys go to jail. They spend a year in jail because the appeal system is very slow in Victoria, getting better, but still very slow. And then, while we're waiting for our appeal, we find that on MySpace she had been saying that she was 17 throughout the relevant period, and that everything that she'd said in court was just a blatant lie. And so, on appeal, we leave fresh evidence, the boys walk out. So, as you can see, the whole criminal process is just alive with social media. Last night I had somebody come in waving posts from Facebook at me. You've just got to get onto it, really. And I'm sure that we, as court-based lawyers, are in court every day dealing with these sort of evidential issues. I'm sure it must be spreading out from what we do. It must be affecting everybody. And get onto it. It's really simple and it's quite a lot of fun. And if anybody has any questions, feel free.